Hi, this is Ravindra Gavande. I'm speaking to you today about labor laws in India. I'm doing this recording on 4th of August 2020. I'm a IR licensing and HR professional and working for a multinational apparel retail company. So let's go through this subject of labor laws in India. I'll quote some questions which come to the minds of a generalist HR or IR professional. How are the leaves of all the people working in the organization are decided? What are the minimum salaries? How are they decided? Who pays more, Mumbai or Delhi? How is bonus determined? Whose salary is more, a security guard or a warehouse or factory operator? How much is employees contribution and how much is employers contribution in provident fund? In ESIC benefit, is it available to workmen after retirement, and then what is the top limit there? And can we employ a 16 years old person for our work at our factory or warehouse or office? How much membership is required to prove that a union is a recognized union? And how do we handle a labor inspector if a labor inspector visits our factory or office or say warehouse kind of premises? So how do we handle that? So these are the questions which come to our mind, and for that we need to have a basic knowledge of labor laws, not very in-depth knowledge, but basic knowledge of labor laws and which laws decide what. And then we can read and go in depth of those laws. All the laws are available on gov.in websites of government, and the labor department has put up the PDF of all the laws on the internet, so one can go and read them. I'm just giving brief introduction of the laws here. Labor laws is the body of laws, administrative rulings and precedents which address the legal rights of and restrictions on working people and their organizations. As such, it mediates many aspects of relationships between government, trade unions, if applicable, and employers and employees. So that is the labor laws. Now I have divided this labor laws into three parts, and in this video I am covering only part 1, that is laws related to wages and laws related with conditions of service. And there are two more parts which I will be uploading very soon. That is, part 2 will be laws related with social security and laws related with equity and empowerment of women. And third part will be establishment specific laws and laws related with industrial relations, and some laws which are not covered in these three categories also I will be covering in part 3. So before going into the first act, I would just like to say that anyone wants the presentation which I am having, the PowerPoint presentation is there with me. They can write to me on my email and I will mail the presentation to them. The email address is given in my presentation. Also, a brief history of labor laws in India. See, in India, the labor laws came from basically England, because England was ruling Indians, and England was first industrialized nation as well. So the history comes from something like 1784, where there were concerns raised in England about working hours of the children employed. And in 1802, the first labor law was passed, and that was called as Health and Morale of Apprentices Act. And then in 1819, they made Factories Act. Then there was one act called India Slavery Act. There was slavery in India. The people used to appoint slaves in India, and English people wanted to eradicate that, and so in 1843 they passed India Slavery Act. Then were some acts like Societies Registration Act, then Standing Orders Act. These went on getting passed in English Parliament, and then subsequently after 1947 we got all the acts. Of course, before 1947 also some acts were passed in Indian Parliament, and that was made with the help of certain politicians who were responsible for that. So first act here is the Payment of Wages Act. It extends to the whole of India. It has been enacted with the intention of ensuring timely payment of wages to the workmen, and for the payment of wages without unauthorized deductions. The salary in factories or establishments employing less than 1,000 workers is required to be paid by 7th of every month by this act, and in other cases by 10th day of every month. Where I was working, one of the establishments had the history of such case where they used to pay salaries late, and then the union was very strong, and they went into the court and obtained the order against the company, and if you violate that order, then that becomes a criminal case. So the Payment of Wages Act, they were kind of complying with after that, and this act applies to wages payable where the wage does not exceed 24,000 per month. So this limit was passed in September 2017, that if the person is drawing more than 24,000 per month, then this act doesn't apply to that that person or that establishment, the Payment of Wages Act. And this act gives definition of what are wages. So in every act you get the definition of wages, but everywhere they say the Payment of Wages Act definition is the final definition. Then the Minimum Wages Act, it extends to the whole of India. The Minimum Wages Act prescribes the minimum rates of wages payable to the employees, also provides maintenance of records and registers and hours of work of overtime, etc., in the interests of the workmen. It provides penalty for non-payment of minimum rates of wages and non-maintenance of records. Here you need to maintain all the records, like the register where the wages are paid, the signatures of the workmen on the revenue stamps, etc., 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 their timings, their overtime, everything has to be maintained, and that is to be shown to the labor inspector who comes for the inspection. There are certain zones for the minimum wages. Zone 1 comprising all areas falling within the limits of all A and B class municipal corporations. Zone 2 comprises all areas falling within the limits of C and D class municipal corporations and A class of municipal councils and cantonment areas. And those who don't fall into 1 and 2, they fall into Zone 3. So when the circular comes, they define the salaries of Zone 1, Zone 2 and Zone 3 separately. And in case your factory or warehouse or office falls within 20 kilometers of Zone 1, then Zone 1 salaries become applicable to you. So that 20-kilometer rule is also applicable in this Minimum Wages Act. Next is Payment of Bonus Act. This act imposes a statutory obligation on all employers employing 10 or more workers in their factories or establishments in India to pay bonus to the employees at the minimum rate of 8.33% or up to 20%, subject to the formula laid down in the act. That applies to factories or establishments from the year they start making profit or from the sixth year onwards, whichever is earlier. and it provides for payment of bonus linked with a scheme of set on and set off. Your accounts person will know what is set on and set off, and of course it is explained very well into the act, as well as on Google you will find many notes on this. An employee who is dismissed for fraud, right like or violent uh, behavior on the premises of the establishment, theft, misappropriation, or sabotage of any property of the establishment is disqualified from receipt of bonus under the act. But you have to provide for the documents at the time of his dismissal or her dismissal. You have to mention one of these reasons and then dismiss the person, and then that person cannot ask for bonus. Also, the minimum service of 30 days of work in one accounting year is necessary for eligibility of bonus under the Act. If the person has worked for 29 days of work, then the person doesn't become qualified for earning the bonus. The bonus is reduced for days equivalent to loss of pay days. That is, if 1 month out of 12 months is loss of pay for the leaves, then the bonus of only 11 months is payable to that person. That is the rule. That is the Payment of Bonus Act. Next important act is Contract Labor Abolition and Regulation Act. It applies to every establishment in which 20 or more workmen are employed or were employed and on any date of the preceding 12 months or as contract labor. The prohibition of employment of contract labor based on certain reasons given under this act, the Labor Department of the state or center can prohibit the employers from appointing contract labor. This is a very serious action that sometimes the labor departments do take, and one has to deal with it very carefully. Licensing of the contractors is also important. There is a RC, registration certificate, online application with number of employees likely to be appointed by each contractor has to be filed for this RC. Once you get the RC, and then you have to fill in the form 5 and then issue it to the contractor for appointing that contractor. Then that contractor has to go to the labor department and obtain the labor license. So that is the procedure. We have to maintain registers and notices and returns and forms for this, and which are and those registers, notices and forms are very important. Like if there is a visit of labor inspector and they don't find these registers, notices and returns and forms records in your company, then they issue a letter to you. If you don't answer to that letter in 15 days, then they issue to you another final warning, and if that warning doesn't get answered within something like 1 month's time, then they have the rights, the labor department has the rights to go to the criminal court for filing a case against the company. And in this case, they file it against the names of all the directors of the company, and then that becomes a serious matter for the HR or IR person who has not looked at answering that notice in time. So that is Contract Labor Abolition and Regulation Act. There is Maharashtra Private Security Guard Boards Act. This is known popularly as Guard Board Act, and the private security guards employed by security agencies deployed at the workplace of principal employers were found to be exploited by the agencies, and therefore the government thought to enact a legislation to regulate the employment and for making better provisions for their conditions of employment and welfare. And that is how ordinance was passed in June 1981 in Maharashtra, and then that was converted into an act on 25th of September 1981, and then this act came into force. So whether the security guards get more salary or the factory workmen get more salary, the security guard as per this act gets something like 23,000 rupees of salary as of 30th of June. This includes all his remuneration, and the security supervisor around 25,000, a security officer around 27,000 rupees of salary. So that is the 5 acts I have briefly covered today in this session. Some tips for handling the visit of labor department or inspector for non-legal or non-IR employees. Treat the government officers nicely, because if on any of your sites they are not treated nicely, and if they are treated very in a rough manner, then they may come out with some punishments for your organization, which can become very costly for the organization. Connect Once you get a visit, connect with your head office or your immediate superior whenever there is an inspection. Don't argue or fight with the inspectors. Give them the normal facts. Don't hide any facts. Carry out the inspection as guided by your head office. Receive the inspection report and just write received and sign on acknowledgement. Sign as acknowledgement. Send the report to head office and your superior immediately by mailing the scanned report, and keep reading the bare acts by downloading the PDFs given in these government.in sites. So that is the message that I would like to give in this first presentation. So please look forward to my second presentation, second of 3 presentations for labor laws in India. Email address is given here, and please subscribe to this YouTube channel so that you get more such videos and alerts. Thank you very much.